supervisor will retaliate or take action against an employee who has rejected his or her advances. As we just talked about, there are a number of other steps that the law expects an employer to take if it's going to avail itself of the affirmative defense, where there's not necessarily an adverse job action that took place, but you still have this concern about a hostile work environment. You've got to have a policy in place. You want to be able to educate your employees. You want to take the prompt remedial action while the investigation is pending. Of course, you do want to do a thorough investigation, take the necessary action at the end, and then, of course, properly monitor and archive all your electronic communications. Let's go to the next slide. We've already talked about limiting authority. Let's talk now about developing a harassment policy. Your policy needs to, and it doesn't necessarily just have to address sexual harassment. It can address racial, religion, whatever the case may be. But you want to make sure that it carefully defines what harassment is. And it needs to be explicit in telling the employees that no harassment will be tolerated. Employees also need to know how they're supposed to report this harassment. And they need to know that reporting harassment is not really an option. It is their duty. They need to do it. I would suggest making harassment reporting a completely separate grievance procedure. And just because of the statistics that are out there, I would suggest making a female the recipient of all of those complaints, and make a female, and put a female in charge of handling that grievance procedure. And certainly you need to at least have a procedure in place so employees can report harassment when it involves somebody who is in their chain of command. In other words, they can report it directly to HR. They don't have to go through their chain of command to report harassment, because obviously oftentimes the harassment is going to be coming from somebody in their chain of command. You need to make sure that they are not going to be retaliated against. Warn employees of the discipline actions that are going to result from violations of the policy. Provide the framework for investigating harassment claims. And this is, given our subject today, this is really important. We need to clearly emphasize that harassment in the forms of emails, IMs, text, or any other forms of messaging are not going to be tolerated. And we also need to make sure that, and this goes to a whole host of issues, but employees need to know that all forms of electronic communications that are using company technology, the company's computers, the company's phones, the company's handheld devices, laptops, whatever the case may be, that those are to be used for business purposes only. And that all these forms of communication using company technology are subject to being searched and monitored by the company. The policy needs to be very explicit in that regard, because we do not want the employees to be able to argue they have any expectation of privacy when it comes to their use of company technology. They need to know that we can search and monitor all of that activity. That's true in the workplace in general. Obviously, we don't want to, employees ought to have an expectation of privacy in the restrooms and maybe certain locker room areas. But generally speaking, they need to know that their desk, their files, their computers, whatever is company property, owned company property, belongs to the company. They don't have an expectation of privacy. If the company needs to, it can search and monitor the activities involving that property. Now, it's one thing to have a policy. We can go to the next slide. It's not enough just to have a policy. You definitely need to make sure the employees have read the policy. You definitely want to make sure at the very least that they have signed an acknowledgement form stating they have read the policy. But better than just simply having them sign an acknowledgement form, you want to make sure that you have taken the time, 10, 15, 20 minutes, and actually educated the employees. And we're not talking about just the non-supervisory employees. We're talking about the supervisory employees as well. They need to attend to some short class and sign off on their attendance. In that class, we want to explain what harassment we're talking about. We want to go through the harassment policy in detail. We want to make sure that they all understand what the reporting procedure is, And if we have said, here's a person that is going to be responsible for taking all harassment complaints, it's good to have that person there so that the employees can put a face with a name. And of course, we want to make sure that all the proper notices that are required by federal and state law are in fact posted. We, again, want to make sure that employees know that they can and will be disciplined for any inappropriate electronic communications. A recent study came out, and it showed that there is now more discipline for inappropriate emails than for dishonesty, violence, and safety issues combined. Certainly communicate that to your employees so they know how serious it is. And of course, as any type of training, the more public examples you can use of inappropriate communications, the better. I know there's a website out there that has a number of communications, I think, that went back and forth between the folks at Enron that are all now public, and that's just a rich source of what not to do. So certainly the more examples you can use, the clearer that message will be. Now, when you do get a complaint, and we can go to the next slide, you've established that you have a policy, you've established that you've educated the employees. When you do get a complaint, generally speaking, it's not enough that you say, okay, we've got the complaint, we're going to investigate it. Once we've done a thorough investigation, it may take several days or even weeks, then we'll tell you what our action is going to be. Oftentimes, depending on the circumstances, courts have looked at that and said, you know what, that's not enough. You should have done something in the interim. So as soon as you get that complaint, start thinking about what it is you can do right then that is prompt to address that situation. And depending on the circumstances, you may want to look at temporary reassignments, paid time off for the complaining employee or the harasser. And you want to make sure that the party being charged with harassment knows that the investigation is underway, no conclusions have been drawn. We don't want to lay the foundation for a defamation suit from the accused. We also want to remind the accuser that they are not going to be subject to any retaliation. We want to give them as much comfort as we can, let them know they're doing the right thing. This is what the company expects them to do. It's their duty. And we don't want a work environment where the type of conduct they're alleging took place, and so we are going to investigate it properly. And we can go to the next slide. When we investigate, this happens, I can't tell you how often it happens, but it happens quite often. The complaining employee files their complaint, and then they realize, and they have some remorse, wow, I've just opened up this huge can of worms. The company's going to come in. They're going to talk to my coworkers. They're going to talk to my boss. They're going to talk to everybody I work with on a day-to-day basis. And this issue is going to be front and center, and it's going to forever change the relationship I have with these people. I really wish I hadn't said anything. I wish I just kept it to myself and maybe looked for a transfer or even looked for another job. That remorse happens all the time, and it's a difficult thing to deal with. You, the company, cannot allow that employee to talk you out of doing your investigation. You must let them know that this is their duty. Promise them that they will not be retaliated against. Let them know that the investigation will be confidential, will be limited to the people who just have factual knowledge of what has allegedly transpired. It's not going to go beyond that. Now, I've got some clients who ignore that advice. I would say under those circumstances, then at the very least, get a legally tight written release from the employee regarding any